So I turn next to guidance and other material relevant to the issue of confidentiality and the duty of confidence owed by doctors to patients. We can pick this up at RLIT 301510, please, Shomik. Taking these in chronological order, if we look at the bottom of the page, we'll see the Declaration of Geneva 1948. We've looked at this in more general terms previously. Bottom of the left-hand column, I will respect the secrets which are confided in me, is how the requirement of confidentiality was embodied in the 1948 Declaration of Geneva. We then look at the top of the page. This is the World Medical Association's International Code of Medical Ethics, adopted by its Third General Assembly in London in 1949. And if we look in the right-hand column under the heading Duties of Doctors to the Sick, the third item is a doctor shall preserve absolute secrecy on all he knows about his patient because of the confidence entrusted in him. And then if we go to RLIT 301504, please. We look at the bottom of the page. We can see here a modification, an amendment made by the World Medical Association in 1968. Left-hand column, last 3 lines. I will respect the secrets which are confided in me even after the patient has died. So that was to make clear that the duty extended beyond the lifetime of the patient. In terms of what we then see in the professional guidance, we can just go back briefly to a couple of the documents we looked at this morning. First of all, GMCO 301697_001, please, Shomik. This was the original 1963 publication by the GMC Functions, Procedure and Disciplinary Jurisdiction. And if we go to page 8, we see there, I referred to briefly earlier, the examples given of what might have been infamous conduct in a professional respect. And one of those is improperly disclosing information obtained in confidence from a patient. Although no further guidance given in relation to that in this particular publication. And then if we go to RCPH 40226, this was the 1949 BMA publication. Page 16, please, Shomik. Bottom of the page, again, we see what was then termed professional secrecy. A practitioner should not disclose voluntarily, without the consent of the patient, preferably written, information which he has obtained in the course of his professional relationship with the patient. And then there was some specific example, a handful of circumstances identified in which it might be legitimate to do that in terms of whether there was risks to others. But we can look at that in more detail in other documents. And then if we look at the GMC's Blue Book from 1977, GMCO 301696_006, and if we go to page 19, we can see under the heading Professional Confidence, the GMC referring here, in fact, to guidance issued or contained within the BMA's Medical Ethics booklet from 1974, but then here promulgated via the GMC's Blue Booklet. The following guidance has been given on the principles which should govern the confidentiality of information relating to patients It's a doctor's duty, except as below, strictly to observe the rule of professional secrecy by refraining from disclosing voluntarily to any third party information which he has learnt directly or indirectly in his professional relationship with the patient. The death of the patient does not absolve the doctor from the obligation to maintain secrecy. There are some exceptions to this principle. If the doctor is in doubt before making any such exception in disclosing information, he should seek advice. The exceptions to the general principle are A, the patient or his legal advisor gives valid consent. B, the information is required by law. C, the information regarding a patient's health is given in confidence to a relative or other appropriate person in circumstances where the doctor believes it undesirable on medical grounds to seek the patient's consent. D, rarely, the public interest may persuade the doctor that his duty to the community may override his duty to maintain his patient's confidence. E, information may be disclosed for the purposes of a medical research project. In such a case, the project should have been approved by a recognised ethical committee appointed for such a person. And then over the page, if in the doctor's opinion disclosure of confidential information to a third party is in the best interest of the patient, it is the doctor's duty to make every reasonable effort to persuade the patient to allow the information to be so given. If the patient still refuses, then only very exceptionally will the doctor feel entitled to overrule that refusal. Again, if in doubt, he should seek advice. And then fourthly, a doctor should be prepared to justify his action in disclosing confidential information. So that's the material published by the GMC and BMA in the course of the 1970s. If we then go to the 1983 Blue Book, GMCO 301696_010, please, Shamik. So this is, if we go to page 22, we can see at the bottom of the page a little more detail here spelt out. Professional confidence. The following guidance is given on the principles which should govern the confidentiality of information relating to patients. While it's a doctor's duty to his patient, except in the cases mentioned below, strictly to observe the rule of professional secrecy by refraining from disclosing voluntarily to any third party information which he has learnt directly or indirectly in his professional relationship with the patient. The death of the patient does not absolve the doctor from the obligation to maintain secrecy. And then we have a number of possible exceptions set out. A is consent from the patient, or it says it's legal advisor, not quite clear what the scope of that was intended to be. B was the sharing of confidential information with other medical practitioners, effectively as part and parcel of a team caring for the patient. And we see from the last sentence of B, it is the doctor's responsibility to ensure that such individuals appreciate that the information is being imparted in strict professional confidence. C is, in particular circumstances, the doctor believes it's undesirable on medical grounds to seek the patient's consent. So in those circumstances, information may sometimes be given in confidence to a close relative or person in a similar relationship to a patient. D then repeats what we saw in the earlier guidance. If the doctor considers disclosure of information is in the interests of, to someone else is in the interests of the patient, the doctor should try and persuade the patient to allow that to be given, but only in exceptional cases could the doctor feel entitled to disregard the patient's refusal. E is where there's a specific statutory requirement to disclose information, such as the notification of an infectious disease. F is direction of the court. And over the page, G is rarely disclosure may be justified on the ground that's in the public interest, which in certain circumstances, such as, for example, investigation by the police of a grave or very serious crime, might override the doctor's duty to maintain his patient's confidence. And then H is information may also be disclosed if necessary for the purpose of a medical research project which has been approved by a recognised ethical committee. And then the guidance continues, whatever...
Can we just go back to B for a moment? B sets out an exception which in the second sentence. Does a receptionist or person working in the reception area in the doctor's surgery come within the description of a healthcare professional?
No. There is reference in some other guidance. I can't, I'm afraid, off the top of my head, remember which. And maybe I'll have to find it and notify it to you, Sarah, at a later stage. But one of the documents, at least, does deal with that particular scenario, the secretary or receptionist, and suggests that it may be permissible for such information to be shared with individuals performing those kind of responsibilities, depending upon how the practice or organisation is structured.
I mean, presume there would be, I suppose, no difficulty with it if the patient, upon coming to the surgery for the first time, were to give a general consent, but that might have to be revisited depending upon the nature of the condition from which the patient was later found to suffer.
Absolutely. Because a general consent to knowing that your GP records recording that you've had a flu vaccination might be something which is accessed by a secretary is very different in nature from knowing that a secretary or receptionist might be able to discover your HIV status. But there is certainly something in one of the documents, but I don't have a note of it off the top of my head, which alludes to the position of the receptionist or secretary. But this would not appear to capture that, because this is talking about nurses, registered medical practitioners, nurses, and other healthcare professionals.
Yes.
And then if we go to the next page, we can see 3 is the requirement that the doctor must be able to justify any decision to disclose confidential information, and a recommendation of seeking advice. 5 deals with particular scenarios such as occupational health, which I don't think we need to concern ourselves with. And then 6 says that the guidance on confidentiality applies equally to medical information which a doctor has received in the course of administrative or non-clinical duties, but it doesn't deal with the situation of people who are not doctors who are performing administrative or non-clinical duties. So that's the 1983 GMC Blue Book guidance, and similar provision is made in later versions of the Blue Book. I won't go through all the various iterations. The next piece of guidance which deals in substance with confidentiality is the BMA's 1988 publication, Philosophy and Practice of Medical Ethics, which is at BMAL 5080. We looked before lunch at the chapter on consent. If we look now at the chapter on confidentiality, it's page 26. And we can see it says the principle of confidentiality is basic to the practice of medicine and fundamental to the doctor-patient relationship. It was contained in early codes such as the Hippocratic Oath. Patients attend their doctor in the belief that the information they supply to the doctor or which the doctor finds out about them in the course of investigation or treatment will be kept secret. And this encourages them to speak frankly and thus provide the doctor with clues or information which can be essential for diagnosis or treatment, etc. And then it talks about how that's desirable for society as a whole. And then if we go to the next page, the third paragraph talks about how the doctor may have reasons for wishing to preserve confidentiality, but the following paragraph says this: despite the doctor's interests in maintaining confidentiality, it must be agreed that the crucial reasons for maintaining it relate entirely to the patient's interests, not those of the doctor. And then the next paragraph deals again with sharing of information with medically qualified colleagues, so, or in multidisciplinary teams. And refers to difficulties in that regard, again, doesn't expressly deal with the person who may not be a member of the multidisciplinary team, may not be a healthcare professional. And then there's some basic guidance, bottom of the page. The doctor's responsible to the patient with whom he's in a professional... Sorry, the bottom of the previous page, my apologies. The doctor is responsible to the patient with whom he is in a professional relationship for the confidentiality and security of any information which he obtains. Next page, a doctor must preserve secrecy on all he knows. The fundamental principle is that he must not use or disclose any confidential information which he obtains in the course of his professional work for any purpose other than the clinical care of the patient to whom it relates. And then it sets out what are said to be the only exceptions to this principle: patient's consent, patient's interest to disclose the information but impossible or medically undesirable to seek the patient's consent. The law requires disclosure. There's an overriding duty to society. Disclosure necessary to safeguard national security, disclosure necessary to prevent a serious risk to public health in certain circumstances for the purposes of medical research. And then, just picking up the bottom of the page under the heading consent to disclosure, the information that a patient obtains about a patient, that a doctor obtains about a patient, remains the property of the patient. However, the patient may in certain circumstances authorise the doctor to share it, and then the further discussion in relation to that. And then the remainder of this chapter deals with what are said to be the exceptions to the principle. Just note at page 33, the heading security of storage and access, and the guidance that the doctor must ensure as far as he can that all medical information is kept in a secure place. That's the the BMA's 1988 guidance. There is then, I won't turn to it, but the Patient's Charter, or the first version of the Patient's Charter, was published by the NHS in October 1991, and that talks about the obligation on staff to keep records, on NHS staff to keep medical records confidential. And then we have some specific guidance from the GMC on professional confidence in the early 1990s. So that's BMAL 40102. So we can see it's guidance for doctors on professional confidence, revised edition published November 1991. And if we go to the next page, we can see at the very top of the left-hand side, this text replaces paragraph 76 to 85 in the GMC's publication, Professional Conduct and Discipline Fitness to Practice. So this essentially extracted from the more general Blue Book type guidance and published in the form of a specific piece of guidance on confidentiality, a similar text. Paragraph 1, under the heading Principles, patients are entitled to expect that the information about themselves or others which a doctor learns during the course of a medical consultation, investigation or treatment will remain confidential. Doctors therefore have a duty not to disclose to any third-party information about an individual that they've learnt in their professional capacity, directly from a patient or indirectly, except in the cases discussed below. And then we can see paragraph 3 talks about doctors carrying prime responsibility for the protection of information and must take steps to ensure, as far as lies in their control, that the records which they keep or to which they have access are protected by effective security systems. And then we can see various examples in terms of exceptions on the right-hand side. So disclosure in relation to the clinical management of a patient in exceptional circumstances. This is paragraph 7. A doctor may consider it undesirable for medical reasons to seek a patient's consent to the disclosure of confidential information, and further guidance there given out, but stress that that's exceptional. And then we see some of the other examples: disclosure required by statute. Paragraph 11, rarely cases may arise in which disclosure in the public interest may be justified. For example, a situation in which the failure to disclose appropriate information would expose the patient or someone else to a risk of death or serious harm. And then if we go over the page, we see paragraph 16, disclosure after a patient's death, fact of a patient's death does not of itself release a doctor from the obligation to maintain confidentiality. So that's the GMC's 1991 guidance. I won't go to it because really these all largely say the same thing, but invite you to note that the BMA in its 1993 publication, which we've looked at this morning, has a section on confidentiality. And then this next piece of specific GMC guidance was issued in April 1999. That's at RCGP 0000-520_107. And you'll see there it's entitled Confidentiality, Providing and Protecting Information, April 1999. We go to page 3. Second paragraph, doctors hold information about patients which is private and sensitive. This information must not be given to others unless the patient consents or you can justify the disclosure. Guidance on when disclosures may be justified are discussed in this booklet. And then if we go over the page, we can see the principles, again, reasonably well established by this time. So the right to confidentiality articulated in paragraph 1, and then various exceptions in which confidential information may be disclosed, set out in the following paragraph. So where there's consent, if we go to page 7, we can see under the heading sharing information with others providing care. Again, this talks about sharing of information amongst colleagues or where care is provided by a team of doctors and other healthcare workers. That's paragraph 13. And then we do get a reference to for example, a secretary in paragraph 14, where patients have consented to treatment. Their explicit consent to disclosure is not always needed before relevant information is shared within a team in order to allow that treatment to be provided. For example, explicit consent would not be needed for a general practitioner may disclose relevant information to a medical secretary who'll type a referral letter, or a physician may make relevant information available to a radiologist when requesting an X-ray unless the patient objects. So that's the GMC's suggested approach in 1999. Whether that's an accurate reflection of the principles in relation to confidentiality may be another matter. And of course may depend upon the context. Don't think there's anything else in this document which deals with the specific example so that you raised. No, there's a reference to disclosure for administrative purposes, but in fact it's not dealing with the issue with which you raised, sir. And then if we go to page 14, we can then see some guidance in relation to disclosures without patient consent. But again, it's the fairly well-established examples where is a legal requirement, so to do, direction of the court, and then the next page, paragraph 38, disclosures may be justified where a failure to disclose information may expose the patient or others to a risk of death or serious harm. So fairly exceptional circumstances articulated there. So those are the principal pieces of guidance from the 70s, 80s and 90s, and indeed to some extent in the earlier materials in relation to confidentiality. There is some specific guidance in relation to the confidentiality of medical information relating to children, and again they're making it clear it's essentially the same principles, but that medical information may be shared with parents or guardians.
Now, just one query. You may not be able to answer this without looking further, but there is a reference in one of the earlier documents to which you've just shown me to medical records being made available to subsequent clinicians who are treating you. That the suggestion there is that in the case of an ongoing condition, should be available to a subsequent clinician. It might be thought to follow that if there is a congenital condition, then that would require, if it were to be honoured, those records of all treatment from the date of birth onwards to be kept and retained for that purpose. It wasn't addressing retention directly. It was looking at the question of confidentiality. But the words would suggest that that is the principle being put forward. Have we got anything else on that?
Not in the material that we're looking at today, no. Again, we are looking more broadly at issues relating to retention of records, so we can pick up upon the point that you've made, sir, and see whether there is any guidance on the retention of records which looks at it from that perspective, so the passing on of care to other clinicians. But there's nothing I can think of at the moment, sir. The next topic then that guidance relates to is the question of medical research. And if I can start with the 1947 Nuremberg Code, that is at RLIT 40372. And we can see just below the heading, the Nuremberg Code 1947, it says this: the judgment by the War Crimes Tribunal at Nuremberg laid down 10 standards to which physicians must conform when carrying out experiments on human subjects. And then we see set out those basic principles, which are said to be observed in order to satisfy moral, ethical, and legal concepts. One is, for present purposes, the most important, although I will go through all of them. One is the voluntary consent of the human subject is absolutely essential. This means that the person involved should have legal capacity to give consent, should be so situated as to be able to exercise free power of choice without the intervention of any element of force, fraud, deceit, duress, overreaching or other ulterior form of constraint or coercion, and should have sufficient knowledge and comprehension of the elements of the subject matter involved as to enable him to make an understanding and enlightened decision. This latter element requires that before the acceptance of an affirmative decision by the experimental subject, there should be made known to him the nature, duration, and purpose of the experiment, the methods and means by which it is to be conducted, all inconveniences and hazards reasonably to be expected, and the effects upon his health or person which may possibly come from his participation in the experiment. The duty and responsibility for ascertaining the quality of the consent rests upon each individual who initiates, directs, or engages in the experiment. It is a personal duty and responsibility which may not be delegated to another with impunity. And then I will, as we're on this document, just read through the further principles. 2, the experiment should be such as to yield fruitful results for the good of society and procurable by other methods or means of study, and not random and unnecessary in nature. 3, the experiment should be so designed and based on the results of animal experimentation and a knowledge of the natural history of the disease or other problem under study that the anticipated results justify the performance of the experiment. 4, the experiment should be so conducted as to avoid all unnecessary physical and mental suffering and injury. 5, no experiment should be conducted where there is an a priori reason to believe that death or disabling injury will occur, except perhaps in those experiments where the experimental physicians also serve as subjects. 6, the degree of risk to be taken should never exceed that determined by the humanitarian importance of the problem to be solved by the experiment. And then over the page, 7, proper preparation should be made and adequate facilities provided to protect the experimental subject against even remote possibilities of injury, disability, or death. 8, the experiment should be conducted only by scientifically qualified persons, and then reference to the highest degree of skill and care. 9, during the course of the experiment, the human subject should be at liberty to bring the experiment to an end if he's reached the physical or mental state where continuation of the experiment seems to him to be impossible. 10, during the course of the experiment, the scientist in charge must be prepared to terminate the experiment at any stage if he has probable cause to believe in the exercise of the good faith, superior skill and careful judgment required of him, that a continuation of the experiment is likely to result in injury, disability or death to the experimental subject. So those are the Nuremberg principles. We then come in 1964 to the Declaration of Helsinki, RLIT 301505. We can see it was adopted by the 18th World Medical Assembly in June of 1964. You can see reference in the second paragraph to the Declaration of Geneva and the health of the patient being the first consideration. And then the fourth paragraph above the heading Basic Principles, in the fields of clinical research, a fundamental distinction must be recognised between clinical research in which the aim is essentially therapeutic for a patient, and the clinical research, the essential object of which is purely scientific and without therapeutic value to the person subjected to the research. And we'll see in that distinction drawn in a lot of the guidance in relation to research, although with a recognition in some pieces of guidance that it's an easy enough distinction to draw in practice, and to describe in principle, but not so easy to determine in practice. And then basic principles. Clinical research must conform to the moral and scientific principles that justify medical research and should be based on laboratory and animal experiments or other scientifically established facts. And then I won't read them all out. 3, clinical research cannot legitimately be carried out unless the importance of the objective is in proportion to the inherent risk to the subject. 4, every clinical research project should be preceded by careful assessment of inherent risks in comparison to foreseeable benefits to the subject or others. And then if we go over the page, so those were the basic principles, and we then see 2 deals with clinical research combined with professional care and 3 with non-therapeutic clinical research. So clinical research combined with professional care at the top of the page says this: in the treatment of the sick person, the doctor must be free to use a new therapeutic measure if in his judgment it offers hope of saving life, re-establishing health or alleviating suffering. If at all possible, consistent with patient psychology, the doctor should obtain the patient's freely given consent after the patient has been given a full explanation. And then 2, the doctor can combine clinical research with professional care, the objective being the acquisition of new medical knowledge only to the extent that clinical research is justified by its therapeutic value for the patient. So that, as it were, is research in the context of actually providing therapeutic care to the patient. That scenario, again, recognises the importance of the patient receiving the full explanation. And then we have non-therapeutic clinical research. Paragraph 2, the nature, purpose and risk of clinical research must be explained to the subject by the doctor. 3A, clinical research on a human being cannot be undertaken without his free consent after he's been informed. 3B, the subject of the clinical research should be in such a mental, physical and legal status to be able to exercise fully his power of choice. 3C, consent should as a rule be obtained in writing. And then 4A, the investigator must respect the right of each individual to safeguard his personal integrity. 4B, at any time during the course of clinical research, the subject or his guardian should be free to withdraw permission for the research to be continued. And then the investigator or investigating team should discontinue the research if in his or her judgment it may, if continued, be harmful to the individual. So that's the 1964 text of the Declaration of Helsinki. It is, as our expert group explained, a document that's been amended over the years, and I'm not going to go through all the various iterations, but that's it in its original form. I think perhaps the only variation or amendment I will show you is the 1975 amendment, which we have at RLIT 301506. And so we'll see this took the text of the Declaration of Helsinki and revised it in the 29th World Medical Assembly in October 75. We can see the heading Basic Principles at the bottom of this page. And if we go over and look at paragraph 9, so again, this is part of the basic principles. In any research on human beings, each potential subject must be adequately informed of the aims, methods, anticipated benefits, and potential hazards of the study and the discomfort it may entail. He or she should be informed that he or she is at liberty to abstain from participation in the study and that he or she is free to withdraw his or her consent to participation at any time. And then if we go to the next page, we can see the distinction retained between medical research combined with professional care, sometimes called clinical research, and then non-therapeutic biomedical research involving human subjects, sometimes called non-clinical research. And just looking at the clinical research, paragraph 5, we see there contemplating the possibility of not obtaining informed consent, but it says if the doctor considers it essential not to obtain informed consent, the specific reasons for this proposal should be stated in the experimental protocol for transmission to the independent committee. There's a later amendment in relation to research on children, but I'm not going to go to that now. If we then look at RLIT 301349, please, Shomik. We can see here a publication or statement by the Medical Research Council in 1964, Responsibility in Investigations on Human Subjects. And if we pick it up, left-hand column, 4th paragraph down, we can see, again, this distinction being drawn between two types of research. A distinction may legitimately be drawn between procedures undertaken as part of patient care, which are intended to contribute to the benefit of the individual patient by treatment, prevention or assessment, and those procedures which are undertaken either on patients or on healthy subjects solely for the purpose of contributing to medical knowledge and are not themselves designed to benefit the particular individual on whom they're performed. The former fall within the ambit of patient care and are governed by the ordinary rules of professional conduct in medicine. The latter fall within the ambit of investigations on volunteers. And then if we look at the heading, procedures contributing to the benefit of the individual, so this first category, what we see there set out wouldn't necessarily accord with what we've seen elsewhere in relation to consent. So if we pick it up 6 lines down, provided that the medical attendant is satisfied that there are reasonable grounds for believing that a particular new procedure will contribute to the benefit of that particular patient, either by treatment, prevention or increased understanding of his case, he may assume the patient's consent to the same extent as he would were the procedure entirely established practice. So you may wish to consider, no doubt, at some stage the extent to which that statement sits with the broader ethical principles and norms that we've had articulated elsewhere, not least by the expert group. And then if we go to the next page, we see, however, at the top of the next, I'm sorry, Shemek, it's actually the previous page, top of the right-hand column. My apologies. So we do see, however, in the second line at the top of the page, that it's both considerate and prudent to obtain the patient's agreement before using a novel procedure is no more than a requirement of good medical practice. So seems to be suggesting here, in the context of this type of research, having said it previously that you can assume the patient's consent, that if it's something novel, it may be good medical practice to obtain the patient's agreement. Not precisely clear what's meant by that. If we go now to the next page, we then see the heading procedures not of direct benefit to the individual. And here, requirements in relation to consent are more clearly set out. So if we look at the third paragraph under that heading, we can see a reference there to true consent. By true consent is meant consent freely given with proper understanding of the nature and consequences of what is proposed. And then if we go to the right-hand column on this same page, top half of the page, third paragraph, investigations that are of no direct benefit to the individual require, therefore, that his true consent to them shall be explicitly obtained. And then we see the reference to adequate explanation. So as at 1964, the Medical Research Council, not necessarily consistent with the international instruments we've looked at, still less with the exposition of principles that we've heard, seems to draw a distinction between these two categories of research. And that distinction's well established, but seems to be saying that the consent of the participant is not really required and can be assumed for the purposes of the clinical research, and that it's all a judgment for a decision for the judgment of the doctor.
Yes, it leaves it as a matter of, quote, good medical practice as opposed to ethical obligation.
Yes.
And it doesn't have any sense of the importance of partnership or autonomy in choices and so on.
It does not. Of course, it's dated July 1964, but we have seen earlier references than that to principles of consent, not least the Medical Defence Union material from the 1950s. And indeed the legal requirements as a bare minimum. The latter part of the 1960s, we can take that document down, thank you, Shemik. The latter part of the 1960s saw a call for the establishment of an ethical review process, and we've put a reference in the notes to a number of documents that deal with the establishment of ethics committees. I'm not proposing to go to those. If we come then to 1970, and again, I'm not going to go back to this, but we looked at the BMA's medical ethics publication from 1970 this morning, and that includes, or without any particular comment, but it includes the Declaration of Helsinki, which, as we saw, talked about the need for consent before conducting research on patients. We then come in the early part of the 1970s to RCPH 40545. This is a publication by the Royal College of Physicians in July of 1973. It's its Committee on the Supervision of the Ethics of Clinical Research Investigations in Institutions. And if we go to the third page, please, Shomik. It refers to an earlier report. We've, again, I think, given the references to this in our note. And then this talks a little more about the role of ethics committees in broad terms. So under the heading Introduction, it tells us that the object of ethical committees is to safeguard patients, healthy volunteers, and the reputation of the profession and its institutions in matters of clinical research investigation. And then if we go to the next page, we can see the heading Explanations to Subjects or Patients who may participate in clinical research investigations. Paragraph A, patients. Wherever the research investigation is not expected or is not intended to benefit the individual, a full explanation of the proposed procedure should be given, and the patient must feel completely free to decline to participate or withdraw at any stage. So that's the category with no clinical benefit to the individual. We then look at the third paragraph. Where the research is intended to benefit the patient, although consent should ordinarily be sought, there are sometimes circumstances in which it's inappropriate or even inhumane to explain the details and seek consent. Ethical committees should examine such cases with particular care. This might be thought to be a minor advance on the 1964 document that we looked at, because it suggests that in relation to research intended to benefit the patient, so the clinical research, consent should ordinarily be sought, so it at least gives it as the starting point, although we then have here articulated in very broad terms a potential exception. Difficult to think of examples in the real world where it might be thought inhumane to explain the details.
Well, it looks as though it is suggesting that the basic approach should be, number one, get the consent of your patient fully informed. Number two, if you don't think that's appropriate, or if you think it might be inhumane, you must go to the ethics committee.
Exactly.
So either way, there's a check.
Yes, precisely, a safeguard. So that was the RCP Committee's 1973 publication. If we just briefly look at RSME 5025, please, Shomik. This is a 1977 publication by the Association of the British Pharmaceutical Industry. The date's on page 3. It's largely focusing on matters such as the design of clinical trials and so on, but it's right to note, if we go to page 11, under the heading Ethical Considerations, you'll see that the recommendation of the ABPI was that the principles adopted should accord with the Declaration of Helsinki. And then, if we look at the last paragraph on this page, it says 2 broad groups of subjects as in participants in research, have been recognised. The first group consists of both patient and non-patient volunteers for whom the procedure is not of direct therapeutic benefit. The second comprises patients who may be anticipated to derive direct benefit, so the same distinction there being drawn. Most of the initial studies with a substance are performed on subjects in the first group. The nature of the trial, its objectives and likely adverse effects should be explained to each volunteer. And then who's asked to freely give their consent. And then it says in patients of the second group, so where there's an anticipated direct benefit to the patient, the validity of the results of certain types of investigation may be reduced by full disclosure to patients, and a certain latitude in explanation may be exercised. The information given to the patient is at the discretion of the clinician in charge of the trial. Go over to the next page. But unless there are any real medical contraindications, it is wise to obtain consent after describing the study to the individual. Again, we see a range of different shades of meaning in these publications in terms of what information should or shouldn't be given to the participant in a study in which it's the doctor's judgment that they may derive some benefit. And then we can go next to the BMA's Handbook of Medical Ethics from 1980, which is at BMAL 5087. And if we go to page 22, we can see the heading at the bottom of the page, Research in Human Subjects. And then if we go to the next page, there's a discussion well, actually, we'll just pick it up at the top of the page. It says, most patients trust their doctors and will consent to any proposal. Experimental procedures are nearly always too technical for patients or non-experts to understand. For practical purposes, therefore, the doctor concerned carries a moral responsibility for the investigations that are or are not proposed to his patient or volunteer. Quite what's meant by moral responsibility in that context is not clear. And then 4.3 so it talks in the second line, volunteers and patients are best protected by ethical conduct. The subject's interests must come first. Then we have reference to controlled clinical trials, 4.4, where it said in the line 4, consent must be obtained from the individual subjects. Then reference to research on children and the processes for clinical trials of new drugs. So it's not, at this stage from the BMA, the fullest or, with the greatest respect, the clearest exposition of the underlying ethical principles. Again, in 1980, there was a specific publication relating to research involving children. This is at RLIT 40658, please, Shomek. And we can see it's entitled Guidelines to Aid Ethical Committees Considering Research Involving Children. It's been produced by a working party of the British Paediatric Association. And then we see these guidelines presume that 4 premises are accepted. 1, that research involving children is important for the benefit of all children and should be supported and encouraged and conducted in an ethical manner. 2, that research should never be done on children if the same investigation could be done on adults. 3, that research which involves a child and is of no benefit to that child, non-therapeutic research, is not necessarily either unethical or illegal. And then 4, that the degree of benefit resulting from research should be assessed in relation to the risk of disturbance, discomfort or pain, the risk-benefit ratio. And then there is, and I'm not going to take time going through the detail of it because it really has to be read really quite carefully in full to follow what's being set out, but there is then guidance as to what's meant by risk, what's meant by benefit, and how the risk-benefit principle could be applied. It's perhaps relevant to note that there's some criticism of the position in relation to guidance on research involving children. A couple of years later in the Journal of Medical Ethics, if we go to RLIT 301381, please, Shomek. Again, I'm not, sir, going to go through the detail of this. It needs to be read in full. But it's an editorial which talks about a range of moral problems associated with research on children. And on the second page, but it's bottom of the first page, and then the second page particularly picks up upon the British Paediatric Association document. And if we just look bottom half of this page, Shomek, left-hand side, we can see in the last 7 or 8 lines of that long paragraph a number of questions being posed in this editorial about the moral acceptability of taking degrees of risk in relation to children. As I say, so it really, one needs to read the full 2 documents, I think, to understand the nuances. But it's an articulation of concern about the state of the guidance and in relation to the ethics of conducting research on children.
Well, on the left-hand side, it focuses upon the definition which we looked at, which it has had me thinking, as you've been speaking, which describes the negligible risk as a risk less than one would have in normal life, which is a bit odd because one has to assume the subject remains alive during the research, and so there'll be a normal life. And the only question is what effect the research has. If it has no additional effect, then I don't see how one can say there's any risk at all, let alone negligible risk. But it's a curious definition.
It is curious. The extent to which the previous guidance, the British Paediatric Association guidance, influenced research in practice in the early part of the 80s is not, I have to say, very clear. That there's much more recent guidance in relation to the ethics of conducting and the parameters of conducting research on children, which our expert group referred to, which is very clear in terms of the circumstances in which research on children is permissible.
Absolutely.
But the position in certainly the early part of the 80s, the materials that we found are not clear.
But it certainly is just a debate which may end up going nowhere in that paragraph all about what on earth is meant by negligible risk or what it is.
And then, again, there are, and I'm not going to go to the various versions, but the position in relation to research is expanded from time to time in the various handbooks published by the British Medical Association. The next document of substance, however, really is some guidelines published by the Royal College of Physicians in 1984, and that is at RCPH 5014. So we can see it's guidelines on the practice of ethics committees in medical research, and the date just below is September 1984. If we go to page 11, so this is talking about what, giving guidance to ethics committees rather than directly to clinicians, but it helps understand what's said to be the ethical principles that should underpin research. So we can see the objectives of ethics committees. The objectives are to facilitate medical research in the interest of society, to protect subjects of research from possible harm, to preserve their rights, and to provide reassurance to the public that this is being done. And then there are a number of points set out. If we just pick it up at the bottom of the page. Every effort will be made to inform prospective subjects of the objectives and consequences of their involvement, and particularly of identifiable risks and inconvenience. And then if we go to the top of the next page, any arrangement to delegate consent has adequate justification, and appropriate safeguards will be instituted to ensure that the rights of the subjects will in no way be abused. Again, I'm not entirely clear what's envisaged by that, but at least contemplated some form of safeguard. And then if we go to the next page, under the heading Definition of a Research Project, it says, definition of a research project that should be put before an ethics committee continues to present difficulties. Any investigation in man designed to develop or contribute to knowledge raises ethical issues, though these may sometimes be quite small. Since any such study may involve subordination of at least the immediate interest of the individual participant to the objective of the advancement of knowledge, all should be subject to ethical review. And then we see the distinction drawn between the two major classes of research, that which involves defined here in slightly different ways from how we've seen it previously. That which involves making observations without any interference with the subject, non-experimental, e.g. use of case records, and investigations that involve interference, experimental. Both raise ethical issues, sometimes large but sometimes very small. Both should be subject to review. And then if we look at the next, so that's a division into non-experimental and experimental. And then we see the more familiar distinction in the next paragraph. Research may also be classed as A, research which may benefit the individual participant, therapeutic research, and B, research that will not or is unlikely to benefit the individual participant, non-therapeutic research. Ethics committees will naturally give close attention to non-therapeutic research. And then the rest of this deals largely with matters of constitution of the committee and modes of working. But if we go to page 22, we then pick up consent as a topic. So paragraph 8, obtaining true or informed or understanding consent is central to the ethical conduct of clinical investigation. The terms true and informed imply that the subject has all the information in a form that's comprehensible to enable him or her to make a proper judgment. The obvious impracticability of this in many cases has led to the saying there's no such thing as informed consent, which is less than fair. And then it talks about different ways of obtaining consent. Modes of consent include, and then we see a distinction between trivial or minimal procedures where verbal consent may be sufficient, more substantial procedures where it's suggested there should be an explanatory document. And then if we go to the next page, if we pick it up at H, the question remains whether there are some undoubted research activities that can be carried out without consent of the patient, e.g. 1, minor procedures that entail no or negligible discomfort to a patient, and where to ask for consent would be more likely to cause distress than to proceed without it. In such cases, the criteria has been proposed that the procedure should not cause appreciably more discomfort than would be experienced by a patient undergoing routine diagnostic procedures for patient care. And then the next category that's discussed is major procedures where to attempt to obtain informed consent can be impossible or devastating, e.g. unconscious patients, may be comprehensible, but then we get acute grave illness, inability to comprehend. In all cases, an ethics committee will give very close consideration to any proposal to proceed without consent and will satisfy itself that the decision not to seek consent from an individual is ethically acceptable. And then bottom of the page, we see use of patient records presents real ethical issues. Care should be taken to ensure that such use is in accordance with current codes of practice. There's then a discussion on research involving children, and there a suggestion that the parent or guardian can consent, and that's further explained. So again, it doesn't really provide an enormous amount of additional practical assistance in understanding the approach, other than the subtext appears to be, or the basic principle appears to be, that save in certain identifiable circumstances, consent should be obtained. And then I think perhaps the next document that's worth looking at is a further document produced by the APBI in 1986, SBTS 605_006, please show it. So this is the ABPI report on good clinical research practice. We see the date July 86. We turn to page 8. Bottom of the page talks about ethics committees and their objectives. The objectives of ethics committees are to protect subjects of research, to preserve their rights and to provide public reassurance. They're also protective of investigators and institutions. And then if we go to the next page, we see an endorsement of, amongst other matters, the Declaration of Helsinki. And then we've got the topic informed consent. The purpose of informed consent is to ensure that the person who's a subject for human experimentation of any form is made fully aware of that experimentation and his/her own rights and responsibilities within that experiment. Properly given informed consent protects the subject investigator and the institution. Subjects should have free opportunity for information, be able to volunteer without pressure to participate. Equally, they should be free to change their minds. And then there's a discussion about how consent to be obtained. Picking it up, fourth line down, written or verbal consent should be obtained only after a full explanation of the study, its aims, the comparator drugs, including placebo, benefits and risks, and where appropriate, an explanation of alternative standard recognised therapy has been given. And I'm not going to go through the detail of it, but if we go to the next page, there's then a more detailed exposition of the elements of informed consent. And then I think the remainder of the document deals with other matters relating to the conduct of clinical trials, which are not particularly material for the inquiry's purposes. And then the next document we may be of assistance is a further report of the Royal College of Physicians, RCPH 40232. So this is published January 1990. It's entitled Research Involving Patients. And then if we go to page 9, under the heading Definitions, we see a discussion of different types of research. So 2.2, when an activity is undertaken solely with the intention of benefiting an individual patient and where there's a reasonable chance of success, the activity may be considered to be part of medical practice. Pausing there, that would suggest that it would bring with it all the normal requirements of good medical practice. And then 2.3, in contrast, where an activity involving a patient is undertaken with the prime purpose of testing a hypothesis and permitting conclusions to be drawn in the hope of contributing to general knowledge, this is research. The fact that some benefit, expected or unexpected, may result from the activity does not alter its status as research. So a slightly different definition here of the two principal forms of research. And then if we look at the next paragraph, there's a recognition that it's not always easy to distinguish between the two. The distinction between medical practice and research is often less clear than is suggested above because both are practiced simultaneously. A doctor who makes careful records of the outcome of treatment, the effectiveness of a diagnostic investigation, or the use of some resource in the course of his ordinary work may be considered to be engaging in quality control, now often referred to as medical audit rather than in research. In general, however, where an effort is made to formalise the acquisition of information gained in the course of medical practice, this may be considered to be at least a component of research. A retrospective review of case records is usually to be regarded as research, particularly where this is undertaken systematically according to a formal protocol or when an individual other than the person who constructed the records undertakes the analysis. Any activity which affects the patient in any way which is additional to ordinary medical practice is to be regarded as research. There's then a discussion about innovative treatment. And then if we go to there was a discussion of consent. Yes, if we go to page 22. Sorry, if we go back first of all to pages 16 to 17, Shamek, my apologies. I'm not going to again go through the detail of this, but I'm just going to flag up what we have here. You'll see, sir, the heading on the left-hand side, risk-benefit analysis. And there's again, quite a detailed discussion about how someone proposing research should approach the question of risk-benefit analysis. And that continues for the rest of this page and over the next page. I don't want to read it all out, but again, it merits careful consideration. And then if we go to page 18, we can see in paragraph 5.23, the third paragraph, talks about the role of the Research Ethics Committee. It needs to do more than a mere risk-benefit analysis. So an analysis of probable benefits, comfort and safety of the participant, and so on. And then the issue of consent is then addressed on page 22. There's reference, so if we just look at the top of the page, first of all, there's reference to the Nuremberg Code. And then Shomik, exactly where you were before, bottom of the page, under the heading consent, paragraph 7.6, there are two important rules for research involving patients. Patients should know they are taking part in research. Research involving a patient should only be carried out with the patient's consent. So those are what's said to be the two important rules. And then, perhaps inevitably, identified what's said to be special exceptions to these rules, which apply to 1, observational research, top of the next page, which is totally without risk or intrusiveness. 2, innocuous research into comprehension. 3, examination of anonymous specimens. 4, research based on medical records. And 5, research into the management of unexpected, overwhelming emergencies. So those are said to be the types of scenario in which those important rules may not apply. And then 7.8 again talks in now familiar terms about consent. For consent to be valid, it is self-evident it must be offered voluntarily and based on adequate understanding. 4 lines down, some research is complex, but we believe it must be possible for researchers to achieve adequate understanding on the part of patients of the reason for the research and the nature of what is intended, including any benefits and hazards, before consent can be sought and the patient enrolled. And then again, there's more guidance as to methods of obtaining consent, provision of information sheets, giving patients time to reflect, and so on. And then I'm not again going to go to it, but I invite you to note at page 26, there's then a section on consent in children. So that's January 1990. There was also then, further on the topic of research in children, a publication by the MRC, Medical Research Council, in January 1991 on the ethical conduct of research in children. I'll just put it briefly on screen so that we can see it, but I'm not going to go through it in detail. Shomik, it's MRCO 40585. I think we've given the date of it in our notice, January 1991. I think, in fact, it may have been December 1991, looking at this. If we go to page 8, Shomik, there's a section on the right-hand side on the ethical case for including children in research. And there's a discussion there about consent at 6.1.3. So 6.1.2 talks about the need for strict safeguards, and then 6.1.3 talks about the consent to be sought where a child has sufficient understanding to consent, and then reference to seeking also parental consent. Then there's then a more detailed discussion of some statutory provisions, in particular under the Family Law Reform Act 1969, which I don't think is going to be particularly useful to you, sir. I think probably the last document, last two documents that I'll refer you to on the issue of research. The first is the BMA's 1993 publication on medical ethics. So we've looked at this for other purposes already. Shomik, it's BMAL 5089. And if you could go, please, to page 221, I think. So there's a fairly detailed chapter in this 1993 guidance from the BMA on research. If we go to page 223, under the heading definitions, bottom of the page, it talks about how confusion sometimes arises from the wide range of procedures covered by the term research, and then bottom of the page talks about the division into therapeutic and non-therapeutic research. If we go over the page, we can see reference to the Declaration of Helsinki and the distinction between therapeutic or non-therapeutic research. And in the last of that, in the last 4 lines of that first section, sorry, can we just go up the page, Chairman? So in paragraph 8.2.1, the BMA says this: despite the implication in the Declaration of Helsinki, the distinction between therapeutic and non-therapeutic research is often not at all clear, with a consequent blurring of the moral focus. And then we see 8.2.2 talks about non-therapeutic research and talks about how that must be subject to full ethical review by local ethics committees, and the subject's consent must be based upon adequate information. There's then a reference to innovative treatments, and the BMA says it's often unclear how new treatments and techniques fit into the framework of ethical review. At present, they're sometimes seen as an extension of the usual treatment, even though such treatments may expose the patient to a more than minimal risk of harm. However, they're often classified as research. And then if we go to the, still under this heading, but the bottom of the next page, this may be of some importance when you're assessing some of the evidence you've heard from clinicians about their involvement in research. It is clear that where the clinician's intention is to acquire new knowledge rather than solely to care for the patient, the constraints applicable to the conduct of research should apply. And then it continues, thus in cases where a doctor proposes for an individual patient a course of action which diverges substantially from normal medical practice with the intention of gaining information which might help future patients, the activity must be subject to review by a local research ethics committee. And then over the next page, under the heading Areas of Overlap, the BMA says this: as has already been mentioned, some projects overlap from one category into the other, but where the focus of attention is not solely the best interest of the individual patient, treatment must be subject to the rigorous standards required for research projects. So it could perhaps be summed up in a rather simplistic way as this: if in doubt, assume that this is something which requires the full panoply of safeguards in terms of ethics committee approval and so on. There's then a more detailed discussion of consent in the context of research from page 229 onwards. Bottom of the page, research brings the risk of causing harm in the practical sense of possibly damaging or disadvantaging a patient, and of doing wrong in the moral sense of ignoring the autonomy of that individual. People are wronged if they are deprived of choice or their values are transgressed on the assumption that the best clinical outcome is necessarily what is best for them. The possibility of harm cannot be entirely eliminated from research, but by insisting that patients have adequate information and choice about participation, we minimise the possibility of wronging them. There's then a discussion about the Nuremberg Code. We go to the next page. Under the heading General Principles, there's then a discussion of the broad fundamental principles of consent. And it says it can be seen the BMA generally lays great emphasis on valid patient consent. And if we pick that up then 5 lines down, the researcher should inform the subject about potential benefits and risks of the procedure, why it's proposed, and the significance in terms of advancing knowledge and the researcher's own stake, if any, in proposing the procedure. Where patients are offered choices, they need information about the alternatives to the treatment recommended by their doctor. When a clinical study is proposed, patients need to know about the advantages and shortcomings of conventional treatments as well as the options in the trial. In any situation, the more risky or invasive the procedure, the greater attention must be paid to the patient's understanding of it and consent to it. And then there's a discussion about some particular issues that can arise in relation to randomised trials. And then reference towards the bottom of the page to the BMA support for the general tenets of the Helsinki Declaration. And then a discussion about information and information sheets in the context of research. There you'll see, from the BMA's perspective in this 1993 publication, a clear emphasis being placed upon the importance of the fundamental principles of consent in the context of research, really, however that research might be classified. And we've detailed various other pieces of guidance in our note which touch on ethical principles governing the undertaking of research. I'm not going to go to any of the further documents, save to just draw to your attention, sir, a report by the GMC published in November 1998, which is talking about seeking patients' consent, the ethical considerations, and talked about the particular importance of obtaining consent from patients participating in research programs. So that brings me to the last main topic for today, which is looking at some of the specific guidance in the context of the ethical issues arising in the AIDS crisis in the 1980s. Perhaps we could take a short break and then pick that up afterwards.
Well, let's have a break for some 20 minutes and come back 25 to 4. 25 to 4.